Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn a subscription. For today's article, we are reading something that's entitled, How Far Will the Second Amendment Be Expanded by the Supreme Court? It's likely just getting started. From your lips to God's ears. If wishing made it so, could we please have some further verbiage on the Second Amendment by the Supreme Court? That would be so great. If you want me to tell you about the First Amendment, I can talk about it for hours because there's lots and lots of case law on it. Not so much on the Second Amendment. Maybe if we had some more cases, the Supreme Court actually heard Second Amendment cases, that would be great, but they don't, but maybe they will. This article seems to think they will, and also seems that there's a lot to fear because maybe the Second Amendment will get expanded. Will our wishes come true? Let's get started with this. Last year's Supreme Court ruling dramatically expanding the reach of the Second Amendment beyond the home and beyond reason. Wow. I don't know, man. I thought it was reasoned. I read it. I read it and I thought it was reasoned and based on, the Constitution and text and keep and bear. And that there should be, that even Heller and McDonald talk about the presumptive bans in sensitive places, which the very phrase sensitive places implies there's such a thing as a non-sensitive place. And maybe the Second Amendment should expand there. But apparently it's beyond reason. I don't know. I've read quite a lot of Second Amendment briefs, and I really think it's quite reasonable. I think it's quite reasoned and flows from its principles and logic, but apparently not. But apparently this wasn't the climax of legal battle over the guns. It was just the opening salvo. Well, no shit, Sherlock, in some sense. The Second Amendment has gone ignored for most of US history. The last case before Heller was Miller, which was 1920s? And Miller was a bit of a garbage opinion. It was poorly written. It wasn't well written. It wasn't even well argued because Miller himself was dead by the time it was argued. Miller's counsel didn't show up because he wasn't being paid. So it was only argued by the US government, and the decision itself is a bit of a mess. And it's a little bit hard to understand exactly what it stands for. And then the Supreme Court kind of ignored it for the next 80 years. And now maybe we're taking it seriously. So yes, it's the opening salvos because now we have a basic right to keep arms and a basic right to bear arms. Wow. And maybe we need to think a little bit more about what that means in its fuller permutations, like we have done in the First Amendment for the last 80 years or so. Every year, the Supreme Court hears a couple First Amendment cases. Why can't we do that for the Second Amendment and flush out the case law? But yeah, it's the opening salvo. Would be nice if we had more shots actually land, but we'll see. The High Court has yet to issue a single opinion in a case on its regular docket this term. Yeah, but it's January. I mean, sometimes they issue decisions really fast, but they only start the first Monday of October. So they've only been in session for 2 months. So you'll start to see things start to come out, but it's a little unusual to have decisions come out sooner, but they treat that like it's a major weird thing, but it's really not. But the so-called shadow docket, the emergency orders it considers in a way much more shielded for prying eyes of the press or public. It's all in the public record, by the way, so okay. Could soon open the door for new victories for pro-gun activists seeking to further dismantle state gun regulation in the Bay Area and beyond. Oh my God. You mean the Supreme Court might actually give full faith to the Second Amendment without even having oral arguments on it? Like they could just issue summarily, just do it? Wow. I don't know what fantasies you've been reading from, but this is sounding pretty good to me. The Supreme Court is going to start just issuing Second Amendment decisions without even having argument over it. It's going to start doing it. Wow, it sounds pretty good. Massachusetts is one of several states that acted swiftly to amend its laws after the court decision in New York State Pistol versus Bruen, and unconstitutionally, especially New York, which is getting whacked around. In that ruling, the court extended the precedent establishing an individual right to carry a firearm outside the confines of the home. That is what the Second Amendment seems to suggest. Keep and bear. So yeah. In doing so, it invalidated laws in New York, Massachusetts, and elsewhere that require showing a proper cause to be issued a concealed carry license. Yeah, because it's a right. You can't do that. Now gun activists are at it again, challenging many of the more limited state laws. Calling them more limited is only true in the most technical sense. Because New York was like, how about we don't issue you a concealed carry permit, period. And now they're like, how about we issue you a concealed carry permit, but you're not allowed to carry it on or within 100 yards of any school, a bus stop, metro stop, park, liquor store, anywhere at all. Or carry where people congregate or where people live or anywhere. Yeah, so it's only more limited in a very, very technical sense, I suppose, in an effort to push the limits of the Second Amendment even further. Man, the limits of the Second Amendment haven't been pushed at all, man. If we treat the Second Amendment like the First Amendment, man, but we don't. This is, crap. One such challenge out of New York has already made its way to the High Court to work. Yes, because they're blatantly defined, if not the letter, and arguably the letter, but definitely the spirit of the decision. A new provision, among others, requires licensing officials to conduct personal interviews with concealed carry applicants, something also in the Bay State's new law. The law also requires applicants to submit social media activity for the last 3 years and prohibits firearms in sensitive places like churches, public parks, and healthcare facilities, and everywhere else. It's a long list. Opponents quickly sued, and federal court preliminarily halted provisions of the law from taking effect while the court challenge plays out. But the Second Circuit Court of Appeals sided with New York because they're stupid. Any ruling the Supreme Court makes on the matter will serve up tea leaves we will all be able to read carefully. Just as the court's shadow docket, allowing Texas's near complete abortion ban to take effect, gave a strong clue that Roe versus Wade was in peril. The Texas decision was very interesting on a lot of technical legal levels that we talked about before. It was very interesting in how it was trying to do things in a way to circumvent legal protection. Incidentally, this of course could be used in the future by people who might want to do things that might be more problematic, but the reaction of the Supreme Court was not particularly surprising because what Texas was trying to do was novel and very creative for that matter. But anyways, they don't care about any of that. An order halting this or other revamped state gun laws would be a sure sign that they too are in the court's crosshairs. Yeah, I would kind of hope a little bit again because Second Amendment needs a little bit love. Pro-gun activists have been clearly emboldened by the recent Supreme Court victory. Yeah, it's nice that they're finally getting some. It took long enough. Justice Clarence Thomas's reasoning in Bruen was strained, contending that virtually any gun registration must be supported by historic analogs, which, it's kind of how we do First Amendment analysis too, to be quite honest. From back in time of slingshot rifles and muskets and quill pens and pamphlets, so is the argument made by challengers. They simply brush away state legitimate concerns about the safety risk of more people carrying guns in public. Yeah, but the Constitution though? What about the Constitution? In fact, it's far more likely the opposite is true. The presence of reasonably armed citizens enhances public safety, the challengers to brief states, despite being repeatedly debunked by facts. The good guy with the myth lives on. I don't know, man. I mean, up until very, very recently, when you pressured the CDC to remove defensive gun use statistics from its websites, the CDC was reporting at least 500,000 defensive gun uses every year. And so, the good guy gun with the myth seemed to have a lot of credibility. So much credibility, in fact, that you pressured them to take it down for political reasons. So, okay. Other laws, including Massachusetts' assault weapon ban, aren't safe either. Oh, really? Please tell me, Santa, you're going to do that? Oh, that'd be great. Groups like the Gun Owner Action League, which sought and failed to challenge that law all the way up to the Supreme Court, are buying their time, weighing the results for current wave of legislation. But as stated on the website, they won't wait forever. Well, they are trying to defend the Second Amendment, and they are waiting until the waters are a little bit better to take more aggressive positions, as one does in law, right? This is the nature of law. It's like, we need to figure out where the boundary lines are, and courts are a little bit slow, which is annoying. And courts tend to be a little bit incremental, which is annoying. But right, we need to figure out where the boundary lines are. And so we need to move the lines further and further and further. And some of these positions right now that some of these people want to take, the gun lobby wants to take, are not currently within the sweep of the current law. They're too far afield, but they may not be forever. And one can hope, right? Because a lot of these laws, not necessarily all of them, but a lot of them are going to have some serious constitutional problems. If state lawmakers' hands become tied, don't expect Congress to help. If there's any glimmer of hope that Congress might build on important, if woefully insufficient gun control legislation passed last year for the first time in decades, it failed this week. Oh, the clutching of pearls is so real. The newly GOP-led House, which Keach even managed to elect a speaker, it did finally do that, thank God, did accomplish one thing, removing the magnetometers that were installed to protect members after the deadly January 6th siege, make it easier for lawmakers to walk to the Capitol complex with pistols on their hips. Their priority is clear. Well, they should walk in with pistols on their hips, if nothing else from their symbolic value. I don't know whether or not they'll allow pistols on the floor of the House, but if they do, that'd be pretty based. And pretty awesome. It's like, I'm gonna show my Second Amendment position by wearing it on my hip every day to work. That'd be pretty cool. I don't know if they'll allow it, but hey, one can hope. That leaves legal battles to be waged between the gun lobby, backed by pro-firearm litigants, yes, and state lawmakers endeavoring to protect and keep their constituents alive with sensible law. Sensible here means woefully ignorant of the plain text and spirit of the Second Amendment in so many ways. Again, some of this might be legal, but they're not even trying to find legal. They're not even close to finding legal. They're thumbing their nose at it. I wouldn't be surprised if the Supreme Court spites them more than they would have otherwise, just out of anger. They're like creating their own enemy, man. Those challenging these laws clearly think they have advantage, particularly at the highest court. Unfortunately, they could be right. Thus, that brings us to the article about how far will the Second Amendment expand. And this article writer is not having it, but they're creating hope in my mind. Hope beyond hope. I don't know that the Supreme Court is going to go this far. And even if they will go this far, not this soon. But maybe this article writer is right. Maybe they're ready to start a new leaf. Maybe they will surprise us all finally, and they will actually give the Second Amendment some actual goddamn consideration like other amendments to the Constitution. We need so much work and so much development on the Second Amendment. There's so much undone because it's been ignored for so long. I don't think I'm asking too much by asking the Supreme Court to take a couple cases every year. They take a couple First Amendment cases every year, and they've done that for the last 80 years straight. Why can't we have a couple Second Amendment cases every year? Take 3 or 5. That'd be nice. How about if we have 5 Second Amendment cases every year so we can start to work on this? Because it needs some love. And these states need to be told that a lot of what they're doing is blatantly unconstitutional. It's not even close to legal. Whatever restrictions they can make, they're so far afield from it, they're just as likely to get completely smacked down, which I suppose is just as well too. And that's the situation. But, hey, we'll see how it all progresses. And at least for a moment, that brings us to end discussion of this case.